Time to head to the courtroom. Just 4 months and 2 days after Lieutenant Windsor Dudley Cecil Hambrough's death, Monson went on trial at the High Court in Edinburgh. It was the 12th of December, 1893.
At 10:30 precisely, Alfred John Monson, the accused, makes his way through the floor as from the underworld into the dock. The prisoner is guarded by 2 constables.
And the charges against you are 1. That you, having formed the design of causing by drowning the death of Windsor Dudley Cecil Hambrough, sometime residing at Ardlamont House aforesaid, now deceased, did in execution thereof bore, or caused to be bored, in the side of a boat, the property of Donald MacKellar, boat hirer, Tinjabrook, a Gaelshire, a hole. And you, Alfred John Monson, and Edward Sweeney, alias Davis, alias Scott, did thus attempt to murder him. 2. That on 10th August 1893, at a part of a wood situated about 360 yards or thereby, in an easterly or northeasterly direction from Ardlamont House aforesaid, that you, Alfred John Monson, and Edward Sweeney, alias Davis, alias Scott, did shoot the said Windsor Dudley Cecil Hambrough and kill him, and did thus murder him.
He repeats his plea not guilty in firm, clear tones. Before any evidence is heard, the famous rowan tree, along with withered boughs of lime and elm trees, dumb witnesses to whose testimony importance is attached, but sadly shrivelled specimens of forestry now, are borne into court and deposited against the wall to the left of the judge. Then, without further preliminary, the first witness is summoned and the trial is underway.
And what a trial it was. The newspapers had a field day. Over the course of 10 days, it's estimated over 1.5 million words were telegraphed in connection with the trial. 76 witnesses were called for the prosecution, 22 witnesses for the defence. There were 241 productions, including pellets and drawings and photographs, letters, cartridges, pawn tickets, medical reports, insurance policies, shotguns, parts of a boat, even, as we've heard, branches from the rowan, beech and lime trees. But the time for hearing and digesting all that evidence is over. I'm Pennie Stuart. This is Inside Forensic Science, the Ardlamont Mystery. Episode 6, The Verdict.
I am quite sure whatever verdict you arrive at will meet the justice of the case, so far as Providence has allowed its mysteries to be revealed. Do your duty. Think of nothing that people may say. Do your duty manfully, either in convicting the prisoner, if you must convict him, or in acquitting him, if you are not tied up to the conclusion on the evidence that you must convict. Gentlemen, that is all I have to say to you. You have listened attentively to this case and know it in all its bearings. And now you have to do your duty by the Crown and by the prisoner.
At 7 minutes to 4 on the 10th day of the trial, just 3 days before Christmas, the jury retired to consider their verdict, possibly in a darkened room with a cold flannel pressed to their collective furrowed foreheads. And while we leave them to their deliberations, we need to do some too. How do we come to a conclusion over whether Monson is guilty, not guilty, or not proven? Because this is a Scottish trial and not proven is a third option. It's another form of acquittal, in fact. And if you want more on that, go and listen to the second series of Inside Forensic Science, where we go into it in detail when we tell the intriguing story of the Glasgow socialite Madeleine Smith, who was accused of poisoning her lover and was tried in the very same court as Monson. If you've been following the Ardlamont case across the previous 5 episodes, it's possible your brain will be feeling as baffled as mine. Even if we set aside the myriad problems we encountered in episodes 1 and 2 regarding the scene of Hambrough's death and how it was mishandled, and if we acknowledge that there were clearly some pretty shady financial shenanigans going on between Monson and Hambrough, which might add up to a motive, as we heard in episode 4. Where I'm struggling is when it comes to the scientific evidence from the expert witnesses about whether Hambrough could have shot himself. All those experiments we heard about in episode 5. Who should we believe? Should we believe the expert witnesses for the prosecution who say, no way Hambro could have shot himself, our experiments show it's just not possible? Or the expert witnesses for the defence who say, yes he could, bit of a crazy accident, I grant you, but then we live in a bizarre old world. In fairness, even our own experts, Rachel Sharp and Duncan Mackenzie, had a differing opinion on this. The role of experts in this case and the cacophony of noise they create by the experiments they carry out, and the sheer unedited volume of evidence that represents, is something I wanted to pick over with Professor Niamh McDade, Director of the Leverhulme Research Centre for Forensic Science at the University of Dundee.
There was lots of experimentation that was undertaken by all sorts of people, the experts on both sides, and in all sorts of different ways. The fact that experts undertake what we would sometimes call ad hoc experiments is not unusual. That experts will undertake experiments relating to the particular circumstances of a case is not unusual. I think what perhaps was a bit unusual here is the volume and also the variability within it. So there were different sets of experiments that were used. Some were used on cadavers, some were used on animals, and so on and so forth, that we're all trying to get to the same answer. Having so many different experiments undertaken by different people isn't that unusual, and it indeed may still happen today, perhaps not quite like this, for these kind of, what they were trying to get to here. A defence expert may conduct their own experiments different from that of the Crown witnesses. What perhaps was a bit unusual is that the Crown witnesses didn't collaborate together to undertake the experiments together or have a plan and say, this is how we're going to do them, this is the kind of set of tests we want to do, now we want to do them multiple times in order to see do we get a consistency of result. It's the fact that everybody kind of went off and did their own thing, and then the challenge with that is at the end of it, somebody has to bring all that data back and try to make sense of it. And you end up with a huge amount of data, all saying potentially kind of sort of the same thing, but some differences. And it's then trying to condense that down and present it to a jury who don't know very much about experimentation and are trying to make sense of what all that data means. And that becomes really challenging.
Now, as I understand it, if you're a scientist conducting an experiment in the world outside of the court, and you get a set of results, and you write that up as a paper, and then it probably is going to be peer reviewed, and people are going to look at your method and how you did it and how robust your science was, and can it be repeated, and all these kind of ways of judging whether science is robust, is good science. How much is ad hoc kind of experimentation within a case subject to the same rigorous ideas of what makes for robust science?
That's a really good question. It's a really complex question. You're absolutely right. If we're scientists doing a set of experiments and we want to publish it, then you need to have a really good grounding of data. And you create that data in your laboratory, and you might do multiple replicates of your experiment to get an idea of repeatability, reproducibility, accuracy, and uncertainty of measurement. So in laboratory-based experimentation, that's where you're heading for. When you're doing experimentation in casework, then that validation may not always be quite as robust. It doesn't mean that ad hoc testing isn't or doesn't have value. It does, but you need to know what it is that you've done. And the jury, who are the triers of fact, need to know the nature of that ad hoc testing as well, I would suggest at least. So ad hoc experiments are okay, but they need to be properly characterised so that when the either expert witnesses from the other side are scrutinising what the Crown witnesses did, or vice versa, but also so that those limitations can be put in front of the jury as well, so that people can make up their own mind around, if you only did that experiment once, then what does that actually really tell us?
From my reading of the trial papers, that kind of rigorous questioning of how robust the science was just wasn't there. Ashley Edwards is King's Counsel and the Principal Crown Counsel, which means she's responsible for about 70 advocate deputes who all prosecute in Scotland's High Court.
So there's this idea that they're all firing shot pellets from different distances, and some of it's into horses' heads and some of it's into cardboard or some of it's into wood. But also the pellets recovered from the trees. We don't know whether those were fresh pellets. We don't know whether they had been from a previous shoot. And there was some suggestion that people regularly shot pigeons in that particular area. So there was nothing to say that the pellets that they were using to work out the whole trajectory that they'd been recovered from the holes, I think, in the trees, was actually the actual shot. And
in part it may have been about the personalities of the scientists. These were the big hitters of the day. And, had given evidence in hundreds of cases. They were very well known. They were almost celebrity status, one could say. And in part, the sheer amount of data that was there, I think, was, to one extent, almost overwhelming. Getting down into the limitations of it didn't seem to be something that was overly questioned by the lawyers in the case. And that may have been to the detriment of both the scientific approach, but also the outcome.
When Niamh mentions big hitters, it's worth noting that Dr. Henry Littlejohn and Joseph Bell for the prosecution were the inspirations for Sherlock Holmes. Bell was in fact Arthur Conan Doyle's tutor when he studied medicine. I wonder if there's sometimes a challenge for legal professionals to understand the science in a case such as this. Ashley Edwards again.
In order to ask the questions of an expert and in order to try and simplify it for a jury, counsel have to understand it. So they have to go back to first principles. They have to understand what it is that they're talking about. Obviously, they're never going to understand it at the same level as the expert, but they really need to understand it. And that's the beauty about consulting with the experts, understanding what evidence the expert is going to give, how it fits in to their area of speciality, and thereafter to try and ask the questions which allows the expert to give the evidence as simply and as straightforwardly as possible.
It could certainly be argued that, in this case, there was quite a bit of variation when it came to experts communicating as simply and straightforwardly as possible. I actually found that the simplest communication came not from the scientists and medical experts, but from the gunsmith, Tom Speedy, which makes me wonder, who gets to decide who's an expert?
The role of expertise is determined by the court. So it's determined by, effectively, the judge with respect to what contribution these people can make. So an expert is somebody who can provide information to the court that is beyond the information available to the ordinary man or woman in the jury in order to enable them to help reach a conclusion. So it may be the gardener and it may be the groundsman, because these people will have specific knowledge of aspects of that place or space at Ardlamont that an ordinary person may not have. And there are other rules about what enables somebody to be called an expert or to be asked to provide expert testimony in court. So one is, do they have, as I said, expertise or knowledge that's above that of ordinary people? Secondly, is that knowledge and expertise being provided in a way that's impartial? Another element is around ensuring that the evidence that expert gives is well grounded in science, if the expert is a scientific expert. So there's a number of rules around admissibility that were followed back then and that indeed are followed now.
OK, so here's a question that's just leapt into my head. Follow it, Nad. If experts are there and deemed to be unbiased, why do you have different experts called for prosecution and defence? Why can't an expert just present the evidence?
So in some courts around the world, that's what happens. That's not how it works here in the United Kingdom or in other jurisdictions around the world. And so when you get experts that are brought into the court that present their evidence on behalf of the Crown and present their evidence on behalf of the defence, what one would hope is that the underlying science is agreed by both. So that if we're talking about something like ballistics, that the underlying principles of how weapons are fired and what happens to bullets as they exit guns or whatever is understood by both parties and both parties agree. Then the bit that comes into the courtroom that is where the experts may disagree with each other is the interpretation and evaluation of the evidence related to the particular case and what that might mean in respect to the propositions or the hypotheses being put forward by the prosecution versus those being put forward by the defence. Our job is to ensure that our evidence is presented in a way that is impartial, that enables the trier of fact, the jury, the judge, to be able to reach a decision.
Even reading this case through the lens of being relatively science literate, I still can't help wondering whether the experts in this particular case almost cancelled each other out. So what happens in court when you've got this kind of tug of war resulting in an impasse? Who wins? Who is the more persuasive? Who gets their evidence over the line to convince the jury?
Sometimes it can come down to the way an expert gives evidence. A good expert can make his or her topic simple, able to convey it to a jury in layman's terms, and when they do that, then then that evidence is landing. So the jury are able to take on board what the expert is saying. And yes, if it's done in a charismatic way, then the jury will remember that evidence. But what's important in how you build the case from a Crown point of view is to talk about how the expert evidence fits in with the other evidence. And so you're going to be putting potentially hypothesis to an expert to say, is that consistent with X having happened? And of course, you have then built up a picture of X having happened with all the other evidence that you've led in the case. And so that's how you make your expert more persuasive, because you fit the evidence in to the rest of your case.
So, how have you been persuaded in this case? If you've gone and looked through the trial papers using the link we've put in the show notes, have you come up with any firm verdict based on the evidence which was presented in court and how it was presented in court? Well, while you make up your mind, and just before we reveal the verdict from 1893, let's have a recap. On the 10th of August, 1893, Windsor Dudley Cecil Hamborough died from a gunshot wound to the head. At first, it was thought to be an accident.
The information above given makes it probable that the deceased was going along the wall with the gun, a short 20 bore under his arm and his finger on the trigger, when his foot caught on something and he plunged forward, put down his hands to save himself, thus lowering the breech, raising the muzzle and pressing the trigger.
Then it was discovered that Hamborough's friend and mentor Monson had taken out £20,000 of life insurance on Cecil Hamborough just days before he died.
All that Mr. Monson said about claiming the insurance money was to ask how he would go about the claim. I said that when the funeral was over, we would arrange that. I told him that we should require evidence of the death before we could discuss it.
The fiscal was suspicious and Monson was arrested. The other suspect, Scott, did a runner and was never heard of again.
Wanted, a man about 35 years of age, looks younger, 5'9" or 10 inches in height.
Cecil's body underwent a post-mortem. Then experts for both the prosecution and defence carried out a massive experiments to try and work out whether Hamborough could have shot himself by accident.
Judging from my experiments and the injuries to the head which I saw, I am unable to see the possibility of the wound having been self-inflicted, accidental, or otherwise.
According to my experience, accidents with guns happen in the most inconceivable ways. I remember the case of a gentleman who was out shooting a year or two ago and who met with an accident. He felt himself falling and flung the gun from him.
So was it murder or an accident? Here's what our own experts thought. First up, expert on finance forensics, Liz Knowledge.
I'm not sure about the shooting accident. I'm really not sure. That's not my area of expertise. It is highly suspicious. But with regards to the finances, we've got a crime here.
But do you think he did the shooting?
I'm not sure.
So you'd go not proven?
I think for the homicide, it's a bit in the balance. I think there needs to be more.
Crime scene manager Rachel Aitken.
I honestly couldn't give a definite answer. You know, we've heard the testimony that the deceased was careless when handling firearms. If the incident the night before hadn't happened, I think it would very much just be seen as an accident and it probably wouldn't have escalated the way it did. I am scientifically minded. I like hard facts to work with. So I honestly do not know, but there are definitely factors that make me suspicious.
I think he was murdered. I really don't buy this shooting yourself in the back of the head. The lack of scorching, I think, is crucial because if he shot himself in the back of the head, the gun would have been much closer. And I think probably, Monson dropped something on the ground, and when he bent down to pick it up, he bent over, he just shot him in the back of the head. That would be my favoured view.
So that's a guilty for pathologist Richard Shepherd. Next up, Rachel Sharp, our forensic firearms investigator.
The defence did a brilliant job of muddying the waters and giving a different scenario. I'm quite concerned that the deceased carries his gun with the barrels up, half-cocked, loaded. It sounds like he carries it as a walking stick, kind of. That's kind of how I pictured it. And if that's the case, he's just asking for trouble. From looking at things in the lab, I think that shot, however unlikely, could have been made accidentally. So then I couldn't rule that out.
I think he was shot in the back of the head with amber number 12, and it was either. I keep going back to it could have been either the two of them, and I got this sneaking suspicion that Scott was here for a job. He might not have had the guts to do it. I don't know.
You think he's a hitman?
I'm suspicious. I mean, we know he's changed his name. He came in. He's had lunch after this guy's been killed. He's a cool character, and then he's disappeared to Glasgow. I'm awful suspicious that Scott was the hitman. He was hired to do it. Whether he actually pulled the trigger or he chickened out, I don't know. My gut feeling is that Scott's murdered.
Duncan Mackenzie. I'm not sure that's entirely helpful at this point in the game, but Scott's story is not quite finished, so don't disappear. It's worth remembering that the jury can only make a decision about the person who is charged and on trial. Scott never appeared, and although that makes him an outlaw, which sounds all a bit stand and deliver, regardless of what part you think he may or may not play, you and the jury can only decide on the evidence presented regarding Monson. In 1893, the jury were gone for just 73 minutes.
Gentlemen, what is your verdict?
My lord, the verdict of the jury is one of not proven on both charges.
What did you make of the not proven verdict in this case?
I think it was probably fair on the evidence that was laid. I have, like everyone else, a strong suspicion that the accused did it, but I didn't see anything that jumped out at me that would stop a jury saying I'm going to give the accused the benefit of a reasonable doubt. So I could see myself being on the jury and saying, okay, on the evidence that was laid, I might have a reasonable doubt. Now that may be because it was difficult to assimilate exactly what was put before a jury from reading the bold transcripts, or it may be that, like you talked about, the jury completely switched off because they didn't know what on earth was going on. But if you take the straightforward facts that the accused had something to gain, he looked like he was certainly making some financial manoeuvrings, and that he might benefit from the death, although there's an argument that he would benefit more for keeping him alive. And so that was a big question. And also the question that you asked me at the beginning was, what was the fundamental question? The first question that had to be answered was, is it possible for this wound to be self-inflicted? And although some of the reports seemed to suggest that it wasn't possible, I'm not sure I picked that up directly from the evidence. I don't think the evidence was as clear as it perhaps ought to have been on that crucial question.
It's really difficult with this one, I think, because there's a lot of suspicion with respect, in my mind at least, with respect to this case being something that happened as an accident. There has to be, I think. Just the nature of the injury and the suggestion that this occurred in a way that was not by somebody else's hand is a difficult one to reconcile. You won't get me saying anything more than that.
Do you think, given everything you've read of the papers, and you've been through them in great detail, and you've obviously got past experience in the police force that you bring to the party as well, Duncan, do you think not proven was an expected verdict from this, really, from the way the trial played out?
No, I can't understand it, to be quite honest. The jury must have been so naive. I mean, it's the judge's job to direct the jury in times of dubiety to a certain extent. But with that compelling evidence from McNaughton the gunsmith, the absolute expert, and Little John the pathologist, both saying conclusively this man was shot about 9 feet. That lead went into his head 9 feet away. How it was not proven, I do not know. That man should be guilty.
So what do you think actually happened?
I think, my gut feeling is that this was a set-up. The day was chosen. It was a nasty day. You wouldn't get lots of people out sunbathing, wandering about. The day was perfect for the job. So I think Monson had to use the amberite, and the amberite was in the 12 bore. So to swing it, he's given the shotgun, the 12 bore, to Hamborough to say in the morning, have a go on the lawn with that, see what you think of that. So that is putting the gun in his hands. Now then Hamborough could have handed it back to Monson, right, let's go shooting pennies. And in August, that bracken's 6 foot tall. They've come together in the middle of this, and one or t'other has shot him in the back of the head at 9 feet. Bang, stone dead. They then have made a plan, or whatever it may be, separated and shouted, Hamborough, Hamborough, where the hell are you? For people, bystanders listening. Oh, they were shouting, they were searching for him. They then said, oh, we found him. Then the whole thing falls to bits then forensically. Scott goes and has his dinner with the doctor, and then the next day he's gone to Glasgow, disappeared. If I had to put a money in it, I would say Scott was the hired man to kill him. Monson took the rap because Scott had disappeared.
While I personally side with Duncan in believing Hamborough was murdered, if I was sat in that jury box as a lay person, I'm not sure I would have been convinced of Monson's guilt by the evidence which was put before me. Interestingly, tucked away at the bottom of yet another column covering the case in Lloyd's weekly newspaper, there's a comment attributed to a jury member who says, but for the judge's summing up, the verdict of the jury would not have been given that night. That's all he says, but we can infer that the jury member thought bias from the judge steered the jury to a particular verdict. If you want to decide for yourself, go and read the judge's summary statement, which starts on page 437 of the case notes and goes on for a mere 33 pages. So maybe the judge just lost his audience. There's a rather juicy postscript to this, which, to be honest, could be a spin-off series in its own right.
20th of January 1894, Liverpool Echo. The Ardlamont Mystery Solved is the title which Mr. Monson has given to the pamphlet, which he has written upon the death of Lieutenant Hamborough. The work is of less than 100 pages and will be published next week by Messrs Marlowe and Co. of 27 Bouverie Street at the price of £1.
Central News interviewed Monson. He announced that he would be releasing a book about the events of Ardlamont from his perspective. He stated one of his goals was to show that he should have received a verdict of not proven at the trial. He also claims he has possession of Scott's diary and that it will be included in the book.
Hang on a second. Scott's diary? How convenient that appears in time for the book's publication.
I have been repeatedly asked to write my version of the Ardlamont case for various newspapers, but the scope afforded by such articles would not have encompassed the end I have in view, and I have therefore resorted to the writing of a book. The real weakness of the prosecution, in my case, has never been fully realised by the public, nor has the logical inconsistency on which the Crown's officials so strenuously sought to fix the crime of murder upon me had been made apparent. Moreover, there are very important facts, some of which, in the excitement of the moment, were strangely lost sight of, and others on which they would have shed an altogether different light. I venture to affirm that a just and discriminating public, when it can calmly and dispassionately read my statement, will come to the conclusion that a verdict of not guilty should have been returned.
We did manage to track down a copy of Monson's book in the University of Edinburgh's collection.
The terrible ordeal through which I have been so recently passed, and the large amount of public attention excited by my case, would naturally dispose me to retire as much as possible from public view, and to try to recover as best I might from the shock to which my system has been subjected. And this is the dominant feeling in my mind at the present moment. But I have a duty to perform, first to myself and family, and I claim the right to say emphatically first to myself and family, and secondly to the public. I know that the personal element should in all cases, even of the most extreme character, be subordinated to the public welfare, and if the circumstances attending the death of my late friend pointed to me distinctly as the cause of his death, the authorities were not only justified in putting me upon my trial, but it was, I admit, their bounden duty to do so. And if, from as impartial a consideration of all the facts as I can command, I could come to the conclusion that those who were responsible for the accusation and trial had justifiable grounds for their proceedings, I would accept all that I have gone through without protest, and even without murmur. But, fortunately or unfortunately, I cannot come to such a conclusion, and it is in the consequence of my inability to justify the Scotch authorities that I now intrude myself upon the public and invite every just and impartial member of the community to carefully consider the facts of the whole case, for they are, one and all, deeply interested in arriving at the truth.
Perhaps unsurprisingly, Monson is very critical of the intentions and reasoning of the prosecution. He also criticises the Scottish legal system, which he says is not calculated to meet the ends of justice.
The English method of procedure afford every facility for arriving at the truth at the time and on the spot, whereas the system pursued in Scotland opens the door to every form of the most abstract speculation, and we witness the spectacle of experts, for and against, arriving at precisely diametrical conclusions.
Hard to argue with that final point, I suppose. His book makes for interesting reading, although I dispute his having solved the Ardlamont mystery as per the title. At the time, it was sold for £1, about £19.50 in today's money. Not a bad earner for a 72-page pamphlet. And Scott's diary? Presumably penned by Monson himself, the diary is alleged to be Scott's account of what happened at Ardlamont and why he did a runner.
No doubt, many will ask why. If I was absolutely innocent of any offence against the law, I should be afraid of arrest. I will answer that by asking another question. Why, being innocent, I should voluntarily sacrifice my liberty and place myself at the mercy of the detective department. The records of the press prove plainly enough that unscrupulous police officers only too often try to make up for their failure to discover real criminals by pertinaciously endeavouring to fox the guilt upon innocent persons, who, on their theory of the case, ought to be guilty. August 16th. I met one of the Crown witnesses. We went into a refreshment bar and had a drink. A lot of Scotland Yard men were having lunch there. I'm always pretty chummy to the force. They're not bad chaps in their way, but it takes a lot of intellectual dynamite to make a hole in a policeman's helmet and let a new idea in. August 18th. Though I was glad to get to London, I felt a strong inclination to run down to Glasgow again. Don't like the notion of appearing to have run away.
I sort of have to admire Monson's creativity, if not his ability to write. Edward Scott, alias Davis, alias Sweeney, wasn't too impressed by Monson's impersonation. And on the 5th of April, he turned up at the offices of the Pall Mall Gazette to clear his name and tell his version of events. The Gazette accompany him to Scotland Yard, who say there's no current warrant out for Scott, so he's free to go.
My readers will say, why was I not at the trial to tell the jury this? But do not forget I never had the chance given to me, and had I gone to Scotland, I should have been popped straight into a cell and without a chance to speak. I've been put in the dock, where my mouth would have been closed and where I could not speak of what I saw and knew.
The problem is, Scott never does seem to speak of what he saw and knew. Read into that what you will. The last we hear of Scott is his appearing in a new magical act by William Morritt called The Missing Man. It features a man claimed to be Scott who is placed in a prison-like cage which is covered and shot at, whereupon Scott disappears and is replaced by two women in evening dresses. As for Monson, by 1898 he's parted company with his wife, and after several different court appearances and a range of creative attempts to make money off the Ardlamont mystery through lectures and magic acts, he's eventually found guilty of money laundering and fraud and is sentenced to 5 years in prison. The last mention of him we found was in April 1904, which suggested he was living in South Africa in order to distance himself from past associates. In the Ardlamont mystery, the experts were Professor Niamh McDade, Ashley Edwards KC, Vincenzo Rinaldi, Duncan Mackenzie, Dr Miles Mack and Dr Richard Shepherd. Particular thanks to the Scottish Police Authority for letting us tap into the expertise of Rachel Aitken, Rachel Sharp and Elizabeth Knowledge. A huge thank you to all our actors: Mark Stephen, David Stenhouse, Chris Dolan, Alan Richardson, Jake Lee, Pam McIntosh, Yana Miller, David Stewart, Neil Wallace, Dan Holland, Sam Young, Paul Murray, Ian Boffey, Andrew Thompson, Craig Swan, Kenny Smith, Andrew Lever, Joe Riley and Donald Peterkin. Inside Forensic Science is written and presented by me, Pennie Stuart. The story consultants and series researchers are Heather Duran and Clara Morris. The sound mix is by Steve Bull. Inside Forensic Science, the Ardlamont Mystery is an adventurous audio production for the Leverhulme Research Centre for Forensic Science at the University of Dundee and is funded by the Leverhulme Trust.